Good afternoon, everyone. So today we will discuss the unit number 7. Unit number 7, 8, 9. Actually, before the change of the new syllabus, before the change of syllabus, it was a part of the CA intermediate. But these were so easy that ICAI decided to transfer to the CA foundation. The first topic is contract of indemnity and guarantee, unit number 7. In today's session, we will have 3 LPL, and I will allow you for sharing your queries, the chat box just before the LPL. So please note down your queries. Please note down your queries. Sir, okay. Please note down your queries. So let's start with the words of great Dr. APJ Abdul Kalam sir. All of us do not have equal talent, but all of us have an equal opportunity to develop our talents. So let's go for your number 7, contract of indemnity and guarantee. This unit will cover section 124 to section 147. Section 124 and 125 are for contract of indemnity, and rest 126 to 147 are for contracts of guarantee. This is for indemnity contract, this is for guarantee contract, right? So the meaning of indemnify. Before discussing the what is the contract of indemnification, contract of indemnity, we should understand the concept of indemnify. Indemnify means to make goods the loss incurred by another person, or to compensate the party who suffered some losses. Means if any person has suffered some loss, to compensate that loss is called indemnify. Section 124 defines the contract of indemnity as a contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser. Promiser means who is making the promise to compensate or to indemnify. Promiser himself or by the conduct of any other person. By the conduct of any other person. So this definition is saying a contract of indemnity means a contract by which one party, let's suppose Mr. A promising to save Mr. B from the loss caused by him. Caused by him means caused by A. Caused to him means caused to B. By the conduct of the promiser means A himself or by the conduct of any other person, third person. But you see in section 124, the loss by natural calamity is not covered. The loss by natural calamity is not covered. For this purpose, a decision was taken in case of Gajanan Moreshwar versus Moreshwar Madan in 1942. You see, section 124 covers the loss caused by the conduct of the promiser himself or any other person. As we have taken the example in previous slide for A and B, by which A is making the promise to B to compensate the loss. So 124 covers the loss by the conduct of A or by any other person. It does not cover the loss by the act of B, by the mistake of B, by any accident or by the act of God, natural calamity. नॉर्मली सेक्शन 124 ने कहा भैया लॉस कवर करेंगे कौन सा हम, जो प्रोमिसर जो प्रॉमिस कर रहा है लॉस कवर करने के लिए वो या कोई और पर्सन। बट इस डेफिनेशन ने ये लॉस कवर नहीं किए। अगर लॉस होता है बाय बी की गलती से, कोई एक्सीडेंट से जिसमें ना एक का कोई था रोल था ना किसी थर्ड पर्सन का था, गलती एक्सीडेंट हो गया, या नेचुरल कैलेमिटी गॉड ऑफ एक्ट ऑफ गॉड। So section 124 covers the loss caused by the conduct of the promiser himself or by any other person. But this definition does not cover the loss by the conduct of the promisee or accident or act of God. So it was decided in case of Gajanan Morishwar versus Morishwar Madan in 1942. Decision was taken on the basis of English law. And the English law provides indemnity means, English law defines the indemnity means promise to save another harmless from the loss. They use the word loss only. It means any loss by any reason, any loss by any reason. Here it covers every loss. It covers every loss, whether due to negligence of promisee, whether due to the mistake of promisee, or by natural calamity or by accident. So section 124 was not complete, but definition was not changed in the act. So if the decision is taken, the court takes the reference of the case of Gajan Morishwar versus Morishwar Madan 1942. Right? Please read this slide. Please read this slide. What are the parties of contract? Parties of contract, the person who promises. We have taken the example, I am repeating once again, A and B, by which A making the promise to B for the making for compensate the loss of B. So the person who promises to compensate the loss is called indemnifier. So indemnifier means in this example is Mr. A. The person to whom the promise is made, to whom the promise is made, to whom the promise is made, or whose loss is to be made good, is known as indemnity holder or indemnified. Let's say an example. Mohan contracts to indemnify Sohan against the consequence of any loss due to fire. Mohan enters into the contract to indemnify Sohan against the consequences of any loss due to fire. Now Mohan is the indemnifier because he is making the promise, and to whom the promise is made is Mr. Sohan. He is indemnity holder or indemnified. Please read. This contract may be in express mode or may be in implied mode. When a person expressly promises to compensate the other from loss, clearly promised by written or by oral, but implied means by conduct, inferred from the conduct of the parties, or from the circumstances of the case. One thing you should note, that all the essential elements of a valid contract, section 10, should also be present in the contract of indemnity. See example number 2, X asks B to beat Z and promises to indemnify Y against the consequences. Y beats Z and fine 1000. Y cannot claim this amount from X because the object of the agreement was unlawful. X ने Y से कहा तुम Z को पीट दो, नुकसान होगा मैं पे करूंगा, ये अनलॉफुल कॉन्ट्रैक्ट है, ही कैन नॉट क्लेम. रीड एग्जांपल नंबर 2 बच्चों. So by discussing the section 124 and the case, decision in the case of Gajan Moreshwar, the contract of indemnity must specify that indemnity holder shall be protected from the loss caused due to action of the promiser himself, any other person. These 2 points are covered under section 124. And by act, event, or accident which is not in the control of parties. These reasons are covered under case of Gajanan Moreshwar. So whenever the question is asked in your exam or question is drafted um, in your exam, and the reason of loss is by the action of the promiser himself or any other person, you may write the section 124. But if in the case the reason of loss is accident, natural calamity, or the promisee himself, so you have to mention the case of Gajanan Moreshwar versus Moreshwar Madan, right? What can be claimed? Section 125. What are the rights of indemnity holder? Right to recover all damages, all losses, all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. Right to recover cost of suit. Suppose uh, in the example, just taking a previous example, what is the example A and B, in which A made the promise to B for making the for compensate the B. Suppose A does not compensate or does not make the payment for damages, B can file the suit in the court. So B can also claim with losses, also claim the cost to recover the suit and other sums like interest. Suppose the claim is due on the month of January, but due to the court case, he has the court matter is settled in the June. So he can also claim the interest amount from the January to June. So in this case, what he in the first point he can claim the actual loss plus cost for cost of court advocate fees plus amount of interest he can claim, right? Sir, please allow the chat box for some time. I will inform you कब बंद करना है. अभी allow कर दीजिए, बच्चे query पूछ सकें. सुन पा रहे हैं सर मुझे? हो गया. तो बच्चों प्लीज if you have any query in section 124 and 125, please share. अमीशा सिंह सर सेक्शन 125. सेक्शन 125 क्या कह रहा है कि हम जैसे ए ने बी से कहा भैया आपको जो लॉस होगा वो पे करूंगा, राइट? अब बी को लॉस हुआ सपोज 1 लाख रुपए का, बी को लॉस हुआ 1 लाख रुपए का, तो अब बी को 1 लाख रुपए लेना है ए से. अगर ए नहीं देता है तो बी कोर्ट में जाएगा. जब बी कोर्ट में जाए, कोर्ट में जो खर्चा होगा, एडवोकेट फीस होगी, वो भी क्लेम कर सकता है. तो जो 1 लाख रुपया है वो तो पॉइंट 1 में कवर हो गया. बी में क्या कवर हुआ? सेकंड पॉइंट में क्या कवर हुआ? जो खर्चा हुआ उस लॉस को रिकवर करने, क्लेम को रिकवर करने के लिए, एडवोकेट फीस, कोर्ट फीस. एंड थर्ड में जो डिले हुआ पेमेंट रिसीव करने में, उस पर जो इंटरेस्ट बनता है वो क्लेम. तो तीनों पार्ट क्लेम किया जा सकता है, राइट? अमीशा क्लियर हुआ बेटा? अमीशा क्लियर? ओके. अक्षित क्या कह रहे हैं? सर इंश्योरेंस इंश्योरेंस कॉन्ट्रैक्ट ऑफ लाइफ इंश्योरेंस फुल कवर्ड, डेफिनेटली कवर्ड सर. पूरा कवर्ड है इंश्योरेंस. तो लाइफ इंश्योरेंस तो पूरा कवर्ड है इंडेमनिटी में. जितना आपने कराया उतने तक के तो लाइबल होंगे आप. किसी की लाइफ की वैल्यू कैलकुलेट नहीं कर सकते आप. यस समर्थ, यू आर राइट बेटा. सर अगर एक अक्षर पूछ रहे हैं, अगर एक कॉन्ट्रैक्ट है टू इंडेमनीफाई बी अगेंस्ट द कॉन्सिक्वेंस ऑफ एनी प्रोसीडिंग विद सी may take against B in sum of 200. Yes. Any other query? So that we can start the first session, first topic of LPL. Okay. What previous स्लाइड में अभी तो डिस्कस किया अक्षित मैंने. आप प्लीज, जब मैं एक चीज मैं रिक्वेस्ट करूंगा हर स्टूडेंट से कि अगर आपकी क्वेरी है, वेल गुड, बहुत अच्छी बात है, मैं बैठा हूँ यहाँ पर. बाकी बच्चों की क्वेरी पे भी आप ध्यान दिया कीजिए सब लोग, ताकि बाकी बच्चों की क्वेरी में ही आपकी क्वेरी भी निपट जाएगी. अभी अमीशा की क्वेरी थी सेक्शन 125 पे, मैंने पूरा बताया आपको, आपने ध्यान नहीं दिया अक्षित, ऐसा ना कीजिए. राइट टू रिकवर ऑल डैमेजेस, अभी बताया मैंने ए और बी का एग्जाम्पल. सर टाइम ए और बी क्या क्लेम कर सकते हैं? एक्चुअल लॉस क्लेम करेंगे, प्लस जो कॉस्ट हुई इनकर्ड हुई उस क्लेम को रिकवर करने के लिए, प्लस इंटरेस्ट जो अगर डिले होता है पेमेंट में उसको क्लेम करने के लिए. सर टाइम गिविंग टू कोर्ट का कॉम्पनसेशन बिकॉज ही इज नॉट गोइंग टू हिज जॉब, ही कैन क्लेम ऑल्सो. सर रीजन फॉर थर्ड पॉइंट इसलिए कि भाई आपको जनवरी में क्लेम मिलना चाहिए था, मिला आपको कब जाके जून में, 6 महीने बाद, तो 6 महीने का ब्याज भी मिलना चाहिए ना आपको, अब डिले हो गया. राइट, बताया था बेटा ये भी मैंने आपको. चलिए, कम टू द फर्स्ट लीग. इंडेमनीफाई मीन्स security from damages or loss, security for profit, and act for protection, both A and B. Section 124 of the Contract Act define contract of minor, contract of condition, contract of indemnity, none of the above. A contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called surety contract, simple contract, contract of indemnity, none of the above. The contract of insurance is in fact contract of urgency, indemnity, both A and B, none of the above. An indemnity holder can recover all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. All costs he may be compelled to pay bringing or defending such suit. All such sum which he may be which may have paid under the term of any compromise of any suit. All of the above. चलिए चेक करते हैं. Indemnity means security from damages or loss. 124 contract of indemnity. Contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is contract of indemnity. Contract of insurance is in fact contract of indemnity. Section 124 to 147 covers both indemnity and guarantee and all the above. ये मेरे पास आंसर 5 क्वेश्चंस के बच्चों ने क्यों भेजे? उश्री दास गुप्ता, यस सौम्यदीप, राइट बेटा। अक्षित, श्रेया, क्वेश्चन 5 पूछना भूल गया मैं? नहीं बेटा, इस पर आया नहीं क्या स्क्रीन पर? ओहो, ये प्रॉब्लम हो गई। कोई बात नहीं, साइड में कुछ कुछ टेक्निकली कोई प्रॉब्लम आई है, अदरवाइज तो मुझे पार्ट पे तो मैंने पूछा है। ओके, सो लेट्स चेक द आंसर। गलती से चला गया शायद। ठीक है। यस अक्षित, कैन नॉट क्लेम। भाई किसी को अक्षित इज आस्किंग सर, इफ ए बीट्स बी एंड फाइन 1,000 रुपए, ए कैन नॉट क्लेम द अमाउंट फ्रॉम बी। अरे भैया, ए ने बी को बोला तुम सी को पीट दो, तो गलत काम किया ना। बी क्या, अगर ए कहेगा बी से तुम इस ए को गोली मार दो, तो गोली मार देगा क्या? नहीं, अनलॉफुल काम किया बी ने, तो कैसे क्लेम कर सकता है ए से? कॉन्ट्रैक्ट ही वॉइड है। आप ये थोड़ी कहोगे साहब मैंने इसने कहा था गोली मारने के लिए, गोली मार दिया, कोई पैसे नहीं दे रहा है मुझे। ये अनलॉफुल नहीं है। ए अगर बी से कह रहा है तुम सी को मार दो, तो ये कॉन्ट्रैक्ट जो ए और बी के बीच में, वो अनलॉफुल नहीं हुआ? डेफिनेटली अनलॉफुल है। ठीक है, चलिए। अब टॉपिक सेक्शन 126 टू सेक्शन 147 बिलोंग्स टू कॉन्ट्रैक्ट ऑफ गारंटी। बिफोर स्टार्टिंग सर, चैट को डिसेबल कर दीजिए प्लीज। कर दिया क्या सर? ओके, थैंक यू। सो बिफोर डिस्कसिंग या बिफोर स्टार्टिंग द टॉपिक कॉन्ट्रैक्ट ऑफ गारंटी सेक्शन 126, we should understand the concept of guarantee. Um, something, the word guarantee was used in normal life about the products. If you are, if normally you are purchasing the product, so some people says, what is the guarantee? Sir, in case of sale of goods, the word is warranty, not guarantee. Guarantee is something different as per the law. So first we should understand the concept of guarantee. Okay, let's take an example. Mr. B, Mr. B asked Mr. C, listen everyone. Mr. B asked Mr. C, Mr. B asked Mr. C, please sell the car to Mr. A. Please sell the car to Mr. A. If A does not make the payment, I will make you the payment. Mr. B asked Mr. C, please sell the car to Mr. A. If Mr. A will not make the payment, if Mr. A will not make the payment, I will make the payment. What Mr. B is saying, sir, give a car to my friend. If A does not pay, I will pay. It means B is giving the guarantee to Mr. C. B is giving the guarantee to Mr. C for the payment of Mr. A. So in this case, if Mr. A does not make the payment, B will be liable for the payment. So in this example, The person who is giving the guarantee is called guarantor और श्योरिटी, जो श्योर कर रहा है, श्योरिटी. The person to whom guarantee is given, the person to whom guarantee is given is called creditor, जिसको गारंटी दी जा रही है. And in respect of whom the guarantee is given is called principal debtor. So the person who is giving the guarantee is called surety. To whom the guarantee is giving is called creditor, and in respect of whom the guarantee is giving is called principal debtor. So the contract of guarantee is between surety and the creditor. So the contract between the surety and the creditor is called contract of guarantee. The contract between principal debtor and the creditor is the contract of sale. And one more contract between A and B. One more contract between A and B, which contract says if B has to make the payment because of the default of A, if B has to make the payment to C because of the default of A, we will recover that amount from A. If B has to make the payment to C, if B has to make the payment to C just because of fault of the A, B has right to recover the payment from A. So in this case, 3 parties and 3 contracts. One contract between A and C, one contract between B and C, one contract between A and B. तो व्हाट इज द एग्जाम्पल, मैं दोबारा एक्सप्लेन कर रहा हूं, हिंदी में रिपीट कर रहा हूं जो मैंने अभी इंग्लिश में बोला. क्या कि बी ने सी को बोला आप मेरे दोस्त को गाड़ी बेच दीजिए, आप मेरे दोस्त को गाड़ी बेच दीजिए, अगर वो पेमेंट नहीं करेगा तो मैं पेमेंट करूं. जिसने गारंटी दी वो कहलाया गारंटर या श्योरिटी, जिसको गारंटी दी गई वो कहलाया क्रेडिटर, क्योंकि उसको पेमेंट रिकवर करना है. जिसके लिए गारंटी दी गई वो कहलाया प्रिंसिपल डेटर, जिसे पेमेंट करना पड़ेगा. तो फर्स्ट थिंग you should note that who is primary liable in such the contract of sale. Suppose in this example, on the faith of B, on the guarantee of B, C has sold the car to Mr. A. So firstly, from whom he will ask for payment is Mr. A. Mr. A, who is the principal debtor, is primary liable. And if A makes the default, then B has to make the payment. And after making the payment to C, B will recover the payment from A. So now come to the definition of section of the contract of guarantee, section 126. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. A contract of guarantee contract is a contract to perform the promise or discharge the liability of a third person in case of default. So who is the third person? Principal debtor. Please note these points. If basic concept is clear, then this topic, believe me, is very easy for you. Please read this example and recall in your mind. Three parties, 3 contracts, 3 parties, debtor, surety, creditor. 3 contracts between surety, creditor, between principal debtor and creditor, between principal debtor and current. Parties to contract of guarantee. Surety, the person who gives the guarantee. Who gives the guarantee. Principal debtor, in respect of whom in respect of whose default the guarantee is given, and the person to whom the guarantee is given is called creditor. So let's take two or three examples on this point. Sandeep requests Chaman to lend 10,000 to Prashant and guarantees that Prashant will repay the amount within the agreed time. If Prashant does not pay, Sandeep, will himself pay to Chaman. There is a contract of guarantee. So Sandeep requests Chaman, Sandeep asks Chaman to lend, give the उधार दे 10,000 को उधार दे दो प्रशांत को, and guarantees that Prashant will repay. If Prashant does not pay, Sandeep will pay. So in this case, who is giving the guarantee? Mr. Sandeep. Sandeep is surety. To whom guarantee is given? Chaman. Chaman is the creditor. And in respect of whom guarantee is given? Mr. Prashant. Prashant is the principal debtor. One more example. S asks C to sell a table fan to P and agrees that if P fails to pay, he will. Means S saying to C that please sell the table fan to P. If P does not pay, I will make the payment. So in case of P's failure to pay, S will recover. No, this is not S. This is C. C will recover the money from. Please read. So on the analysis of definition of contract of guarantee, that is section 126, there are three contracts between principal debtor, creditor, and surety. First contract is between A and B, principal debtor and surety. One contract is between surety and the creditor. Third contract between creditor and the principal debtor. So the contract of between B and C is the contract of guarantee. It is a normal contract. Let's say, suppose contract of sale, and this is the contract for reimbursement or compensation. Because if B has to make the payment on behalf of A, we can recover it from A. Three contracts. What are the essentials of for a valid contract of guarantee? First thing, the purpose of guarantee should be to secure the payment of debt. Debt means here liability. Liability. Liability may be for the payment of goods, may be for prepayment of loan. Liability. The guarantee is for the payment of liability. If there is no liability, there is no valid guarantee. If there is no liability, for example, A has given a guarantee. Let's take an example. A has given a guarantee to B to sell the goods to C. And if C does not make the payment, A will make to C. If C does not make the payment, A will make the payment to B. But if in this case B does not sell the goods, then there is no guarantee. भाई A ने B से कहा आप C को गुड्स बेच दीजिए, अगर C पेमेंट नहीं करेगा तो मैं आपको पेमेंट कर दूंगा, मैं गारंटी दे रहा हूँ. B ने गुड्स बेचा ही नहीं C को, और सी पेमेंट नहीं करता है तो फिर गारंटी किस बात की? भाई जब गुड्स ही नहीं बेचा, लाइबिलिटी अराइज ही नहीं हुई, तो गारंटी भी नहीं होगी। एग्जिस्टेंस ऑफ लाइबिलिटी, द डेब्ट और लाइबिलिटी मस्ट बी लीगली एनफोर्सेबल एंड नॉट टाइम बार्ड। इफ द लाइबिलिटी बिकम टाइम बार्ड, 3 साल निकल गए, आपने क्लेम ही नहीं किया, 3 years have been passed but you didn't claim, then there is no case of guarantee. Example 6, A gives the guarantee to B. A gives the guarantee to B for the payment of a time bar debt due to from C. This is not a valid contract. This is not a valid contract. Please read this slide. Consideration. Contract of guarantee should be supported by some consideration but need not be a direct consideration. Please underline, need not be a direct consideration between sureties and the creditor. Direct consideration means uh, if surety is giving guarantee to creditor, if surety is giving guarantee to creditor, there is no need, there is no need that creditor should make some payment or give some consideration directly to the surety. Any benefit received by the debtor is an adequate consideration to bind the surety. Suppose surety is giving the guarantee to creditor to make the surety is giving the guarantee to creditor to make sale to principal debtor. So sale by creditor to debtor is the indirect consideration for the contract of guarantee by surety to creditor. ये जरूरी नहीं है कि श्योरिटी और क्रेडिटर के बीच में डायरेक्ट कंसिडरेशन हो, राइट? अगर क्रेडिटर ने गुड्स बेचा श्योरिटी के कहने पर डेटर को, तो ये सफिशिएंट कंसिडरेशन, ये इनडायरेक्ट कंसिडरेशन है। किस बात के लिए? जो श्योरिटी ने प्रॉमिस किया गारंटी का, उसके लिए कंसिडरेशन माना जाएगा। P requests C to sell and deliver to him 100 kgs of sugar on credit. S guarantees the payment. Here C promises to deliver the goods to P is sufficient consideration for S promise. Therefore, the guarantee is valid. Listen once again. P requests C to sell and deliver to him 100 kgs of sugar on credit. P requested C to sell deliver 100 kg of sugar. C guarantees the payment. Here C's promise to deliver the goods to P is sufficient consideration for S promise to C. कि भैया S का जो प्रॉमिस किया C, उसके लिए कंसिडरेशन क्या है कि जो C गुड्स बेचेगा P को। प्लीज रीड द एग्जांपल 7 once again. Last essential point, there should not be any misrepresentation or concealment in the contract of guarantee. See the example. S guarantees to C payment for 100 quintal of wheat to be supplied by him to P at market price. What is the example? C has to supply 100 quintal of wheat to P and S has given the guarantee for making such payment. What S saying? S saying, sir, please sell the goods to P. If P does not make the payment, I will make you payment. But what actually happened? P privately, principal debtor privately agreed that he should pay 10 rupees per quintal extra to C. So P privately agreed with C that he will pay the 10 rupees over the rate decided. But this was done without the knowledge of surety, that is Mr. S. Without the knowledge of guarantor, that is Mr. S. This is the concealment of fact, and hence S will not be liable as surety. Most simple example. क्या था, एस ने सी को कमिट किया, मैं गारंटी दे रहा हूं आप 100 क्विंटल गेहूं बेच दीजिए, किसको, पी को, मार्केट प्राइस पर, मैं गारंटी दे रहा हूं अगर पेमेंट नहीं करेगा। पी ने चुपचाप सी से कहा सर मैं आपको 10 रुपए एक्स्ट्रा दूंगा, बस माल भेज दो मुझे। ये बात गारंटर को पता नहीं थी, यानी गारंटर के सामने कुछ चीजें छिपाई गई या झूठ बोला गया। इस केस में गारंटी खत्म। अगर मान लीजिए इस केस में P पेमेंट नहीं करता है, if in this case if P does not make the payment, if he makes the default in payment, S will not be liable as guarantor. S will not be liable as guarantor. A contract of guarantee may be written or oral, but have to be proved. It may be oral but have to be proved. Who will prove? The creditor has to prove or the debtor has to prove. Joining of other co-sureties, important. Where a person gives guarantee upon the condition that the creditor shall not act upon it until another person has joined in it as co-surety, the guarantee is not valid if that other person does not join. Suppose a contract was entered between S1 and C for guarantee in respect of P. In respect of P, S1 says to C, sir, please sell the goods to P. If P will not pay, me and S2 will pay, but on the consent of S2. But on the consent of S2. S1 ने कहा सी से, सर आप P को माल बेच दो, अगर P पेमेंट नहीं करेगा तो हम पेमेंट करेंगे, मेरे साथ S2 पेमेंट करेगा, वो मुझे, he will join me as co-surety, but only when S2 will join. ये कॉन्ट्रैक्ट जब भी वैलिड हो गारंटी का जब S2 मुझे एज ए को-श्योरिटी ज्वाइन करेगा, मैं अकेला लायबल नहीं होगा। The contract of guarantee is valid only if S2 join me as co-surety, otherwise I will not be liable. So in this case, the contract of guarantee between S1 and C will be valid only if S2 joins as co-surety. If S2 denies, sir, I am not ready to join, then S1 will also not be liable. Then S1 will also not be liable. Where a person gives a guarantee upon a condition that the creditor shall not act upon it until another person has joined in it as co-surety, the guarantee is not valid if that other person does not join. Please read, important point for examination point of view. Next topic is types of guarantee. Guarantee is of two types, specific guarantee and continuing guarantee. A specific guarantee extends to a single transaction. If a guarantee is given for a single or a specific transaction, it is called specific guarantee. And surety's liability comes to end when the guaranteed debt is fully discharged, is due to discharge. Means, if suppose S has given guarantee to C for to sale of FEN to P, and if P makes the payment, the contract is discharged, S is discharged from the liability. But continuing guarantee is a series of transactions. Series of transaction. Series of transaction. And surety liabilities continue until the revocation of guarantee. It means surety continue will be liable until he revokes the guarantee. Until he revokes the guarantee. Let's take an example. Let's take an example. A suppose let's S asks C. C is the C. S asks C, please sell the goods to P in the month of May 2026. in the month of May 2026. I am giving the guarantee for all transaction which will be done in the month of 2026. एस ने सी से कहा आप मई के महीने में जितने भी माल बेचोगे सी को मैं सबकी गारंटी लेता हूं. सीरीज ऑफ ट्रांजेक्शन, दिस इज कॉल्ड कंटिन्यूइंग गारंटी. And this guarantee can be revoked only. This guarantee can be end only if the guarantor revokes the guarantee. कि गारंटी जब वो रिवोक करेगा, भैया मैं 5 दिन हो गए, suppose in this example as says to see after the 5th May, after the 5th May, sir, what is done, I am responsible, but the guarantee is over now. I will not be responsible for any transaction from now. सपोज कि एस ने अभी एग्जाम्पल में डिस्कस किया हमने, एस ने गारंटी दी सी को कि भैया मई में आप माल बेचो, पी को जितना बेचोगे मैं गारंटी दे रहा हूँ, मैं लायबिल हूँ अगर पेमेंट नहीं करे. 5 मई को उसने कहा भाई साहब बस खत्म, गारंटी खत्म. लेकिन 5 मई तक जो भी ट्रांजेक्शन हो गए ना उसके लिए एस लायबिल होगा. तो इफ द गारंटी इज रिवोक्ड फॉर ऑन 5th May, the S will be liable up to the all transaction from the date up to the date of revocation. Example 9. Avdesh guarantees Mukesh, a canteen owner, to supply lunch to his employee for time to time up to the value of 10,000. The guarantee given by the Avdesh was a continuing guarantee and he is accordingly liable to Mukesh to the extent of 10,000. What is in the example? Avdesh asking the canteen owner Mukesh, ki please supply the lunch to my employees, but I am liable to, as a guarantor up to the amount of 10,000. If you provide for more than 10,000, I will not be liable. So this is the continuing guarantee because it is series of transaction up to amount 10,000. Please read this example. Difference between contract of indemnity and guarantee. A question may be asked for 5 marks in your exam, 4 to 5 marks. Parties in contract of indemnity, though 2 parties, but in contract of guarantee there are 3 parties. Number of contracts: indemnity 1 contract, guarantee 3 contracts. Primary liability is that of indemnifier. In case of contract of guarantee, the principal debtor is primary liable. Surety liability secondary, means if the primary liable is the principal debtor, if principal debtor makes default in payment, then surety will be liable. Commencement of liability arise only on the happening of contingency or event. In case of guarantee, the liability of surety arise only on the default by principal debtor. Suit: the indemnifier can sue the third party in its own name unless there is assignment in the indemnifier favor. Otherwise, he must bring the suit in the name of indemnifier. अगर किसी कहना चाह रहा है कि फाइल कौन करेगा सूट? इंडेमनीफायर. इंडेमनीफायर सूट करेगा. Please. Indemnifier cannot sue the third party in his own name unless there is an assignment in the indemnifier's favor. Otherwise, he must bring the suit in the name of indemnified. Means suit कौन फाइल करेगा? Indemnified suit करेगा. लेकिन अगर indemnified assign कर दे अपना राइट किसको? indemnifier को, तो वो अपने नाम सूट फाइल कर सकता है. In case of contract of guarantee, principal debtor fails to pay the surety discharges debt, the surety can proceed against the principal debtor in his own name. Means the principal debtor makes the default and surety has to make the payment. Then surety can claim the payment from principal debtor. The indemnifier need not act at the request of the indemnity holder. The surety act at the request of principal debtor. Purpose: what is the purpose of contract of indemnity? Reimbursement of loss, compensation for loss. And contract of guarantee, security of the payment to the creditor. Nature and extent of surety liability. Listen. Section 128 provides the liability of surety is co-extensive with that of principal. That is, the surety is liable for what the principal debtor is liable. Please underline, surety is liable only for that amount for which principal debtor is liable. However, the contract of guarantee may provide otherwise. See the example number 10. X gives guarantee to Y for the payment of debt of 10,000 due from Z. Means X has given the guarantee to Y. Sir, you have to receive the payment of 10,000 from Z. I am making the guarantee. I am making the guarantee that if Z does not pay, I will make the payment. Z could not make the payment. Z ने payment नहीं किया. An unknown person made a payment of 2,000 to Y on behalf of Z. But now what is actually happened? When the Z makes the fault in the payment, X will be liable. But actually what happened, an unknown person make the payment of 2,000 to Y on behalf of Z. Now the balance liability of Z is only 8,000. Y has received 2,000 on the liability of 10,000. So as the Z is liable for 8,000 only, X will liable only for the same amount. क्या था एग्जाम्पल? एक्स ने गारंटी दी वाई को कि सर आपने जो जेड को लोन दिया है 10,000 रुपए का, मैं गारंटी देता हूं, मैं पेमेंट करूंगा अगर वो पेमेंट नहीं करेगा. जेड ने पेमेंट नहीं किया, डिफॉल्टर हो गया. लेकिन एक अनजान आदमी, एक अनजान फरिश्ता दुनिया में आया और उसने जेड के ब्याह पर 2,000 रुपए दे दिए. सो जेड की लाइबिलिटी कितनी बची? 8,000 रुपए की. 2,000 तो मिल गए भाई को. तो जब जेड की लाइबिलिटी 8,000 बची है, तो जो एक्स है गारंटर, उसकी लाइबिलिटी भी 8,000 रुपए की ही होगी. बट वन लाइन इज एडेड. The contract of guarantee, the contract of guarantee may provide otherwise. Means it was decided in the contract between X and Y. It was decided in the contract of X and Y. Sir, even your payment is of 10,000. I would be liable only for 4,000. एक्स और वाई में गारंटी आपस में तय कर सकते हैं कि भले ही आपका पेमेंट 10,000 रुपए का था, मैं तो 4,000 की गारंटी दूंगा, केवल 4,000 रुपए नहीं आएंगे तो वो मैं लाइबल हूं. So this may be provided in the contract of guarantee. The liability of surety arises only on default by the principal debtor. Principal debtor cannot directly file the suit, cannot directly demand the payment from surety. First, he asks the payment from the debtor. Then, in case of default by debtor, the creditor will ask the payment from surety. Where the debtor cannot be held liable on account of any defect in the document, the liability of surety also ceases. अगर कोई कमी थी, कोई डिफेक्ट था डॉक्यूमेंट में या कुछ प्रोडक्ट में, और by which debtor is not liable, so surety will also not be liable, because the liability of surety is that same that debtor. If the principal debtor makes a default, creditor asks the payment from surety, surety also make the default, surety also denied, then principal debtor can directly file the suit against the creditor can directly file the suit against the surety. Third line saying, creditor may choose to proceed against the surety first unless there is an agreement to the contrary. Means अगर प्रिंसिपल डेटर ने डिफॉल्ट किया, पेमेंट नहीं किया, क्रेडिटर कहां गया? श्योरिटी के पास, हाथ जोड़ के भाई साहब पेमेंट कर दो. श्योरिटी ने भी मना कर दी, तो उस केस में क्रेडिटर डायरेक्टली श्योरिटी के ऊपर केस फाइल कर सकता है. इफ द क्रेडिटर मे चूज टू प्रोसीड अगेंस्ट द श्योरिटी फर्स्ट अनलेस देयर इज एग्रीमेंट टू द कॉन्ट्री. सर, अब बच्चों के लिए चैट बॉक्स अलाउ कर दीजिए इस पार्ट के लिए.
Done, sir.
Okay, sir. Please ask your query up to this part. Up to this part of session, please ask your queries. X and Y go into the car showroom where X says to dealer to supply latest model of Wagoner to Y. In this case, Y's failure. Yes, this is contract of guarantee. Akshit, example 10. Just a minute. Example 10, Mr. Navdeep. Sir, in example 10, what actually happened? X is the guarantor and Y is the creditor. He is giving guarantee to Y and Z is the principal debtor. Z has to make the payment of 10,000 to Mr. Y. So if Z makes the default, X will be liable for the same amount for which Z is liable. So Z has to make the payment of 10,000, X will be liable for 10,000. But suppose an unknown person made the payment of 2,000 to the creditor, that is Y. So the liability of Z is reduced to 8,000. The fault amount is the default amount of Z is rupees 8,000. So the surety will also be liable only for the same amount, not for 10,000. Sir, can time and energy lost be compensated or not in the court of law? You can apply, the court will decide. Who promises X or Y? In which question, Akshit? Sir, no misrepresentation or concealment. अगर कोई चीज छुपाई गई श्योरिटी से, प्रिंसिपल डेटर और क्रेडिटर ने आपस में तय कर लिया, श्योरिटी को नहीं पता, तो कॉन्ट्रैक्ट क्या हो जाएगा? गारंटी कॉन्ट्रैक्ट कैंसिल हो जाएगा, खत्म हो जाएगा. If surety does not make the payment and dies, then can be suit filed against the legal heir? Yes, definitely yes. But stay. I will discuss some points on this part. I will discuss some points in after the break on this part. Wait. जरूरी नहीं है. अब डेथ के बाद क्या होगा वो डिस्कस करते हैं डिटेल में. Sir, please explain conclusion of it. Which point, Kashish? Arun guarantees that Pushpa will repay. If Pushpa does not, Arun will pay Babita lend 10,000 to Pushpa. सर, अगर अरुण श्योरिटी है, पुष्पा डेटर है, तो क्रेडिटर कौन है? अरे भैया बबीता ही तो है, तुमने तो लिखा है. सर, in last example, why not creditor directly case on principal debtor? नहीं. Creditor first ask for the principal debtor. If he does not pay, he should go for the surety guarantor and he may also file the suit against the principal debtor. Sir, if concealment occurs, then the principal debtor will be liable. Definitely, yes, he will be liable, but surety will not be liable. Yes, Akshit, you are right, beta. Sir, what if surety dies? We will discuss. Wait. Essentials में फोर्थ और सिक्स पॉइंट. फोर्थ पॉइंट क्या था? अगर कोई चीज अभी तो बताया बेटा, प्लीज आपने सुना नहीं. अगर प्रिंसिपल डेटर और क्रेडिटर श्योरिटी के बिना बताए, श्योरिटी को बिना इन्फॉर्म करे कुछ चीजें टर्म्स चेंज करते हैं, छिपाते हैं, तो श्योरिटी की लायबिलिटी नहीं रहेगी. सिक्स पॉइंट कहता है अगर श्योरिटी ने ये कहा है सब मैं गारंटी दे रहा हूं, लेकिन मेरे साथ एक दूसरा को श्योरिटी भी ज्वाइन करेगा, S1 S2 एग्जाम्पल दिया था मैंने, तभी ये गारंटी वैलिड होगी. तो अगर S2 ज्वाइन नहीं करता है तो गारंटी वैलिड नहीं होगी. राइट? एनी अदर पॉइंट? Sir, suppose if principal debtor could not pay 8,000, so surety must pay 8,000 now. Surety can claim 10,000 if principal debtor unknown from this fact. No, no, no. The surety, we are, sir, listen. Sandeep is asking, suppose if the principal debtors couldn't pay 8,000, so surety must pay 8,000. Now surety can claim for 10,000 if principal debtor unknown from this fact that unknown person already paid 2,000. Sir, we are discussing law. Law means right things, not unlawful things. अगर 8,000 दिए तो you should claim the 8,000 only, ना? एग्जाम्पल एस 8 की लास्ट लाइन का मतलब क्या है? श्योरिटी इज नॉट लाइबल एज श्योरिटी, मतलब श्योरिटी की लाइबिलिटी खत्म हो जाएगी. सर श्योरिटी बैंकरप्ट हो जाए तो उसकी प्रॉपर्टी क्लेम कर सकते हैं. वेट करिए, वी विल डिस्कस ऑन द राइट्स एंड लाइबिलिटीज पार्ट. क्विंटल लाइन से डाउट है. एग्जाम्पल 8 बिल्कुल सिंपल था भाई. 100 कुंटल का कॉन्ट्रैक्ट हुआ क्रेडिटर और डेटर के बीच में. श्योरिटी ने गारंटी दी. प्रिंसिपल, डेटर और क्रेडिटर ने आपस में तय कर लिया जो प्राइस तय था उससे 10 रुपए एक्स्ट्रा देंगे. श्योरिटी को नहीं बताया तो श्योरिटी से अगर कोई बात छिपाई गई तो श्योरिटी की लाइबिलिटी खत्म हो जाएगी. ओके, सो लेट्स गो फॉर एलपीएल सेकंड मैच. Implied contract means by conduct, by behavior. If his person is by behavior making the payment, it is a guarantee by implied contract. Come to the match number 2. A guarantee which extends to a series of transactions is called special guarantee, continuing guarantee, specific guarantee, none of the above. A, in consideration that B will employ C in collecting the rent of B's jamindari, promises B to be responsible to the amount of 5,000 rupees for the due collection and payment by C in those rents. This is a restricted guarantee, continuing guarantee, limited guarantee, none of the above. Guarantor means surety, principal debtor, all the above, none of the above. The contract of guarantee is a contract in which a person performs the promise or discharge the liability of contractor, stranger, third person, none of the above. In a contract of guarantee, for whom guarantee given is called surety holder, principal debtor, both A and B, none of the above. The guarantee is valid even if space is incompetent contract. Principal debtor, surety, both A and B, none of these. Guarantee which extend to a series of transactions is called continuing guarantee. A, in consideration that B will employ C in collecting the rent of B's jamindari, promises B to be responsible to the amount of 5,000 rupees for the due collection and payment by C of those rent. This is a continuing guarantee. Guarantor means surety. Contract of guarantee is a contract in which a person performs the promise or discharge the liability of a third person. In contract of guarantee, for whom guarantee is given is called principal debtor. The guarantee is valid even if principal debtor is incompetent, because main person is surety, who is giving the guarantee. The final responsibility, final liability of the surety. The principal debtor is incompetent, the surety even that will be liable. Okay, so let's check. Akshit, Dakshta, Sandeep, Rudra, Ushri, Jyoti. So second part is complete, but before going for the break, I just want to take a query from Ekampreet Kaur. Example 9. Bete, in example number 9, Avdesh given the guarantee to the Mukesh, the canteen owner, for which up to the amount of 10,000. Please allow the employees, for my employees, for the food, but up to 10,000. This is the continuing guarantee. Sir, liability of surety arise on principal debtor. ये तो अलग क्वेश्चन ही गलत है. सर, अगर प्रिंसिपल डेटर श्योरिटी को धोखा दे के पैसे लेकर भाग जाए तब भी श्योरिटी लायबल होगा. यस, बिल्कुल होगा साहब. ठीक है. सो एट दिस प्लेस वी आर हैविंग अ ब्रेक ऑफ 5 मिनट्स. 5 मिनट का ब्रेक दीजिए बच्चों को सर, और चैट को डिसेबल कर दीजिए प्लीज. सर सुन पा रहे हैं क्या?
यस
अजीत
सर,
सर, चैट
अच्छा
बॉक्स
सर, सुन
डिसेबल
रहा
कर
सर.
दीजिए प्लीज, और ब्रेक दे दीजिए बच्चों को 5 मिनट का.
हाँ हाँ.
ओके. Yeah, चालू हो गया. Okay, welcome back everyone. Now time to discuss the modes of discharge of surety, how the surety will discharge from the liabilities. By revocation, by conduct of creditors, by invalidation of contract of guarantee. By revocation, we will discuss by notice, by surety's death, by novation. By conduct of creditor, we will discuss by variance in terms, by release of or discharge of principal debtor, composition with principal debtor impairing surety's remedy. On invalidation of contract of guarantee, we will discuss guarantee obtained by misrepresentation, guarantee obtained by concealment, guarantee on contract that creditor shall not act on it until the co-surety joins. So first, discharge of surety by revocation, first by notice. We have discussed in the previous slide the guarantee is of two types. Guarantee is of two types, a specific guarantee and continuing guarantee. So law says a specific guarantee cannot be revoked once the liability is incurred. It means if the creditor has sold the goods or transfer the money to the principal debtor, surety cannot withdraw the guarantee. But in case of continuing guarantee, a surety can withdraw the guarantee, can revoke the guarantee for future transaction only. The transaction which have already done in the past, he will continue to be liable for those transactions. See example number 11 as guarantee C for the transactions to be done between C and P for next month, full month. But after 5 days, S informs C, that is the creditor and principal debtor, that he is not surety anymore. Guarantee is now revoked for future transaction, but S is still surety for transaction done during the previous 5 days. Guarantee was given for the month, but after 5 days, the surety revoked the guarantee. But this guarantee can be revoked only for the future transactions. So for the 5 days, the transaction done in the 5 days, he will still be liable as surety. By death of surety, some of students ask, sir, what about on the death of surety, whether legal heir will be liable or not? See, on the death of surety, a continuing guarantee is automatically revoked in respect of future transactions. However, surety's estate, surety's property will remain liable for the past transactions which have already taken place before the death of surety. See example number 12 as guarantee C for the transaction to be done between C and P for the next month. After 5 days, S died. Now guarantee is revoked for future transaction, but S estate will still be liable for transaction done during the previous 5 days. जो 5 दिन में हो गया उसके लिए उसकी प्रॉपर्टी लाइबल होगी. Sir, what about specific guarantee? Sir, what about specific guarantee? Sir, specific, if liability incurred, then again the property of surety will be liable. If liability is not incurred, for example, P as guaranteed as giving the guarantee to C to sell the goods to P. If C has sold the goods to P and after that surety died, the surety's property will be liable. But if Surety death is before the transaction of sale by C to P, then guarantee will be end. अगर श्योरिटी स्पेसिफिक गारंटी है, सी को पी को माल बेचना, जिसकी गारंटी कौन दे रहा है? एस। अगर वो ट्रांजैक्शन हो गया है, सी ने पी को माल बेच दिया, उसके बाद डेथ होती है तो प्रॉपर्टी लायबिल होगी। अगर उससे पहले डेथ हो जाती है तो उसकी लायबिलिटी खत्म। बाय नोवेशन, नोवेशन मीन्स न्यू कॉन्ट्रैक्ट। When old guarantee is substituted by new one, the old guarantee is automatically discharged. If new guarantee contract of guarantee is done, then old contract is ended, revoked. See example number 13. As guarantees C for the payment of supply of wheat to be done by C and P for next month. As guarantees C for the payment of supply of wheat to be done by C and P for the next month. After 5 days, the contract is changed. Now S guarantees C for the payment of the supply of the rice to be done by C and P for the rest of next month. Here guarantee is revoked by supply of wheat, but S is still liable for supply of wheat done during the previous 5 days. Read the example carefully. S guarantees C for the payment of supply of wheat to be done by C and P for the next month. S ने गारंटी दी थी, अगले महीने आप माल बेचो, सी से कहा बेचो पी को, मैं पेमेंट करूं। After 5 days, contract is changed. Now S guarantees C for the payment of supply of rice in place of wheat for the rest of next month. But S is still liable. S is still liable for supply of wheat done during previous 5 days, means before the novation. यानी 5 दिन के बाद गारंटी चेंज हो गई, वीट से राइस पे आ गई, तो जो 5 दिन में वीट ट्रांसफर हुआ ना, सी ने पी को बेचा, उसके लिए वो श्योरिटी लायबल रहेगा। प्लीज रीड दिस एग्जांपल वंस अगेन। Now discharge of surety by conduct of creditor. It means creditor has done something by which the liability of surety is discharged. Variance in terms of contract. Variance means change. If subsequent to the formation of contract of guarantee, means contract of guarantee is done, after that any change or variation is made in the terms and conditions of the contract of guarantee, and such variation is made without consent of surety, the surety shall be released for such transaction as take place after such variation. Means contract of guarantee is already done. After that, principal, debtor and creditor make some change without the consent of surety, then surety will not be liable. See example number 14. C enters in a contract to supply 100 tons of timber to P, which was lying in godown of C at Shimla. C enters into contract to supply 100 tons of timbers to P, which was lying in godown of C at Shimla, as gives guarantee to C for payment. Thereafter, P agrees to receive timber lying down at the godown at Fulan at the request of C, but no consent was taken from S for such change as is discharged from the liability. Original contract for supply of timber which was lying at Shimla, but after that location was changed. Timber was lying at the Solan, and this was not informed to the surety. So any change without the permission or consent of surety, then in that case surety will be discharged from the liability. Please read example number 14, बच्चों. Section 134 and 138, release or discharge of principal debtor. If surety, the surety is discharged if the creditor enters into a new contract with principal by which principal debtor is released. Means creditor informs the principal debtor, please make, I'm making you free from the liability. I will ask the payment only from the surety. क्रेडिटर ने कहा भैया मैं आपको माफ कर रहा हूँ, प्रिंसिपल डेटर ने कहा आपको माफ कर रहा हूँ, आपसे पेमेंट नहीं मांगूंगा, केवल श्योरिटी से मांगूंगा. इफ प्रिंसिपल डेटर इज रिलीज बाय द क्रेडिटर, श्योरिटी इज ऑटोमेटिकली रिलीज फ्रॉम द लायबिलिटी. और creditor does any act or omission, the legal consequence of which is the discharge of principal debtor. कि creditor has done something by which principal debtor is automatically discharged, then surety will also be discharged. See example of 15. P contracts with C for a fixed price to build a house for C within a stipulated time, within a specified time. C supplying the bricks as guarantees P's performance of the contract. If C does not supply the bricks to P, S will not be liable. Contract was entered between P and C by which P will build a house for C and C will supply the bricks. S becomes the surety for the contract between P and C by saying to C, sir, if the P will not make the payment, I will make the payment. But in this example, C has to supply the bricks on time. And C could not supply the bricks on time, principal debtor is also not liable to complete the house on time. And in this way, if principal debtor is free, surety will also be discharged from the liability. Please read the example number 15. Composition with principal, section 135. Composition means settlement. You can say the settlement. Settlement. The surety is discharged if the creditor makes a composition settlement with or gives some time or agrees not to sue the principal debtor without obtaining the consent of the surety. Means creditor is saying to the creditor, sir, I am giving you the time for making the payment, or I am promising you I will not file the suit against you. But this is without the information or the consent of the surety. क्रेडिटर ने किससे कहा, प्रिंसिपल डेटर से कहा भैया जाओ मैं तुम्हें टाइम दे रहा हूं पेमेंट करने के लिए और 15 दिन बाद कर देना, या मैं तुम्हें प्रॉमिस कर रहा हूं सूट फाइल नहीं करूंगा. इन दिस केस अगर ये बातें अगर श्योरिटी को नहीं पता है तो श्योरिटी विल बी डिस्चार्ज फ्रॉम द लायबिलिटी. सी एग्जांपल नंबर 16. सी सेल्स AC to P on which the payment to be made after 2 months as guarantee for the same as surety. On due date, P requests to extend the time for payment by 15 days without informing to S. Payment to be made within 2 months. On due date, P requested C without informing surety for extend the time. And creditor allows 15 more days for payment without the knowledge of surety. Now surety will be discharged. Now surety will be discharged. Important slide, examination point of view. Exception to point number C, cases where surety not discharged. What we have discussed in this slide number 45, if creditor gives time or agrees not to sue the principal debtor, surety will be discharged. But these points says the surety will not be discharged if situation is in such way. First point, surety not discharged when agreement made with third person to give time to principal debtor. Please underline third person. Anjan admi, stranger. If in the previous example, which was the example? Please read once again the example. C sells AC to P on which payment to be made after 2 months. S guarantees for the same as surety. On due date, P requests C to extend. P requests C, creditor, to extend the time for payment by 15 days. C allows without informing S. Hence, here S will be discharged. But see this example, number 17. If in the previous example, that is 16, P requests Z. P ने Z से request की third person से, अनजान आदमी से. P requested Z to extend the time for payment by 15 days. Time time should be allowed, time should be extended by the creditor only. P request third person, unknown person Z, sir please मेरा time बढ़वा दो payment के लिए. Z said okay, done. So in this case Z, who is Z? बेगाना अब्दुल्ला, बेगानी शादी में अब्दुल्ला दीवाना. ठीक है, who is Z? So Z, if Z is giving the time, who is not a part of the contract, S will not be discharged. Creditors forbearances to sue does not discharge surety. Creditor forbearance to sue does not discharge surety. If creditor says to principal, I will not file the suit against you. C sells AC to P on which payment to be made after 2 months. S guarantees for the same as surety. On due date, P did not make the payment. C did not sue the P for next year. C ने सूट फाइल किया ही नहीं 1 साल तक. एस की लाइबिलिटी खत्म नहीं होगी. एस की लाइबिलिटी खत्म नहीं होगी because if the default is made by the principal debtor, surety will be liable and principal creditor can directly file the suit to the surety. Impairing surety's remedy. Impairing means reducing. श्योरिटीज रेमेडी, जो श्योरिटी को बेनिफिट मिलना था उसे अगर कम कर रहा है क्रेडिटर, श्योरिटी, if the creditor is reducing the benefit or remedy to be given to the surety, then surety will also will be discharged from the liability. C, it is the duty of the creditor not to do anything which is inconsistent with the rights of surety. Surety has right, if principal debtor makes default, then surety has to make the payment on behalf of principal debtor. But surety has the right to claim that payment from principal debtor. अगर प्रिंसिपल डेटर पेमेंट नहीं करता तो श्योरिटी पेमेंट करेगा क्रेडिटर को, पर वो पेमेंट श्योरिटी से क्लेम भी तो, श्योरिटी डेटर से क्लेम भी तो करेगा. So it is the duty of the creditor not to do anything which is inconsistent with the right of surety. If creditor fails to protect the surety's right, the surety is discharged. See the example number 19. C takes up P as apprentice on a fidelity guarantee given by S. C promises on his part that he will at least once a month see that P makes up the cash. C omit to C has done as promised and P embezzled. C is not liable to C, S is not liable to C on his guarantee. Please read this example, then I will explain again. Please read this example, then I will explain again. पढ़िए बच्चों एक बार इस एग्जाम्पल को. He takes up P's as apprentice. Apprentice means trainee. Trainee. ट्रेनिंग. सी टेक्स अ पी एस ट्रेनी ऑन ए फिडेलिटी गारंटी. विश्वास दिया है, गारंटी दी है कि भैया ये आदमी सही रहेगा एस ने. C promises on his part that he will at least once a month see that P makes up the cash. और सी ने ये प्रॉमिस किया कि भैया मैं हर महीने में कम से कम एक बार चेक करूंगा कि प्रॉपर कैश आ रहा है या नहीं आ रहा है. यानी जो पी को जो ड्यूटी दी गई है प्रॉपर कैश जमा कर रहा है कि नहीं कर रहा है. सी ऑमिस टू सी दिस डन एज प्रॉमिस. सी ने लेकिन ध्यान नहीं दिया, महीनों ध्यान नहीं दिया, और क्या हुआ, पी ने गबन कर लिया, एम्बेजल कर दिया. S is not liable to C on his guarantee. Now please read once again. Example number 19. Okay. Now discharge of surety on invalidation of contract of guarantee. Guarantee obtained by misrepresentation. Something making false statement. The surety discharge any guarantee given which has been obtained by means of misrepresentation made by the creditor concerning a material part of the transaction. Material part, important part. C, C sells AC to P on misrepresenting that it is made of copper while it is made of aluminum. And S guarantees for the same as surety without the knowledge of the fact that it is made of aluminum. Means C has made contract with P for selling of AC by saying that the compressor is made of copper, but actually it was aluminum, and this fact was not known to S also. Even he is giving the guarantee, he will not be liable because C has made the misrepresentation in the contract with P. C sells AC to P on misrepresenting that it is made of the copper while it is made of aluminum. S guarantees for the same as surety without the knowledge of the fact that it is made of aluminum. Hence, here S will not be liable as surety. Guarantee obtained by concealment. Previous was false statement. This was hiding the truth. Section 143. Guarantee obtained by concealment. Section 143. The surety discharge a guarantee, any guarantee which the creditor has obtained by means of keeping silence as to the material circumstances. Example 21. S guarantees to C payment for 100 quintals of wheat to be supplied by him to P at market price. P privately agreed that P should pay rupees 10 per quintal extra to C, which is not in the knowledge of S. Now there is a concealment of fact from S, hence S will not be liable as surety. This example were already discussed by me in previous slides. Please read once again this example. और डिस्कस कर चुका हूं बच्चों में, फिर भी वह पढ़ लीजिए इसको. Guarantee on contract that creditor shall not act until on act on it until co-surety joins section 144. Where a person gives guarantee upon a contract that the creditor shall not act upon it until another person has joined in it as co-surety. The guarantee is not valid if that other person does not join. Suppose person is giving guarantee on the condition that, sir, I will be liable only if the other person join me as a co-surety. And if that other person does not join, the main guarantor will not be responsible, will not be liable. See example number 22. S1 guarantees C for the payment to be done by P to C on the condition that S1 will be liable only if S2 joins him for such guarantee. If S2 does not give the consent, S1 will not be liable. Please read the example number 22. Now the rights of surety. What are the rights of sureties? against debtor, rights of sureties against debtor, against creditor, against co-sureties. Against debtor, he has a right of subrogation, a right of indemnity. Against creditor, he has a right of security, right to set off, right to share reduction. Against co-surety, the surety has a right to claim contribution equally, a right to claim contribution only agreed sum. Let's discuss one by one. Rights against principal debtor. First right of surety against principal debtor is the right of subrogation. A right of subrogation. Section 140 provides on payment of debt, the surety shall be entitled to all the rights which the creditor could claim against the principal debtor. In simple words, this point wants to say that if the principal debtor makes default and surety has to make the payment because he was the guarantor, so surety will have all the rights what the creditor already has. It means the surety will put on the shoes of the creditor. अगर प्रिंसिपल डेटर पेमेंट नहीं डिफॉल्ट करता है और श्योरिटी को पेमेंट करना पड़ता है तो श्योरिटी को सारे राइट मिल जाएंगे जो क्रेडिटर के पास थे यानी क्रेडिटर से क्लेम कर सकता था प्रिंसिपल डेटर से उसी तरीके से श्योरिटी भी क्लेम कर सकता है सो ऑन पेमेंट ऑफ डेट on behalf of the principal debtor, the surety will have all the rights which belongs to the creditor. See example number 23. Raju has taken a housing loan from Canara Bank. Pappu has given guarantee for repayment of such loan. Besides that, there was a condition that if Raju does not repay the loan within the time, the bank can auction his property by giving 15 days notice to Raju. On due date, Raju does not repay the loan. Hence, Pappu being the surety has to repay the loan. Now, Pappu can take the house from bank and has a right to auction the house by giving 15 days notice to Raju. What was the example? The Raju is the principal debtor. He has taken a loan from the Canara Bank. Canara Bank is the creditor, and Pappu is the guarantor. The contract between the Raju and the Canara Bank that if the Raju does not make the repayment of loan, then bank has right to make the auction of the property by giving 15 days notice. If the Raju makes the fault, Raju has made the default in payment, so Pappu, because he is the surety, is the guarantor, has to make the payment. Has made the payment. Now Pappu has right of creditor, that is same right as that of the Canara Bank. He can auction the property by giving the 15 days notice to Raju. Right of indemnity, compensation. Section 145. In every contract of guarantee, there is an implied promise by principal debtor to indemnify the surety. Means if the surety is entitled to recover from principal debtor whatever sum he rightfully paid under the guarantee, but not sum which he paid wrongfully. Means there is an implied contract between principal debtor and the surety that surety, if the surety has to suffer any loss due to because of the principal debtor, he can recover from principal debtor. See example number 24. X took a loan from Y, which was guaranteed by Z. On default by X, Y filed a suit against Z. Z has to pay some legal expenses besides the loan of X. Now Z can claim that legal expenses also from X. Legal expenses also from X. X ने लोन लिया Y से, गारंटी दी Z ने. एक्स ने लोन में रीपेमेंट डिफॉल्ट किया, वाई ने सूट फाइल कर दिया जेड के अगेंस्ट, गारंटर को लीगल एक्सपेंसेस पे करने पड़े. तो अब जो गारंटर है वो क्या क्लेम करेगा एक्स से? लोन का अमाउंट और जो खर्चा हुआ लीगल एक्सपेंसेस हुए वो सब क्लेम करेगा. प्लीज रीड द एग्जांपल नंबर 24. Now right against creditors. Right to get security. If some security has been deposited by the principal debtor to the creditor, if some security has been deposited by the principal debtor to surety, and principal debtor makes the default, the surety has to make, sorry, listen, I'm repeating my words. If any security has been deposited by the principal debtor to creditor, if any security has been deposited by the principal debtor to creditor, and principal debtor makes the default, and surety has to make the payment, then surety can recover that security from the creditor. अगर कोई सिक्योरिटी प्रिंसिपल डेटर ने जमा कराई थी क्रेडिटर के पास और वो पेमेंट में डिफॉल्ट करता है और इस वजह से श्योरिटी यानी गारंटर पेमेंट करना पड़ता है, गारंटर पेमेंट करना पड़ता है, गारंटर पेमेंट करना पड़ता है, तो वो गारंटर क्रेडिटर से वो सिक्योरिटी रिकवर कर सकता है. Surety has right to demand from the creditor all the securities which the creditor has against the debtor, whether they had been received before or after the creation of guarantee, or whether those are in knowledge of the surety or not. Surety को पता हो या नहीं हो वो क्लेम कर सकता है. See example number 25. Pratham took an advance of rupees 1 lakh from Chaman, which was guaranteed by Samar. Thereafter, Pratham gave jewelry of 1 lakh to the Chaman as security, which was not in knowledge of Samar. After some time, Pratham became insolvent. Chamal filed a suit against Samar. At that time, the market value of jewelry was 95,000. Then Samar is liable only for 5,000. Pratham has taken a loan of 1 lakh from Chaman, guaranteed by Samar. Pratham has deposited the jewelry as a security. Pratham become insolvent. Now the value of market value of jewelry is 95,000. So the liability of Samar is only 5,000. Balance amount, right? A right to set off adjustment. A right to set off adjustment. On being sued by creditor, the surety may have the benefit of the set off, if any, the principal debtor had against the creditor. See, example 26, X took a loan of 5,000 from Y, which was guaranteed by Z. There was one another contract between X and Y in which Y had to pay rupees 1,000 to X. On default by X, Y filed suit against Z. Now Z is liable for 4,000, that is 5,000 and 1,000. Again, come to the point. Right of set off means right of adjustment. Surety has right for adjustment. Let's take this example number 26. Loan was principal debtor. Loan was 5,000 from Y. Y is the creditor. Z is the surety. Another loan in reverse way. X and Y. Y had to pay 1,000. So the balance liability of X is rupees 4,000 because he has to make the payment of 5,000 and he has to recover 1,000 from Y. So we have already discussed the liability of the surety is same that of principal debtor. So in this example, the X, that is the principal debtor, is liable only for 4,000 balance amount. So same way, the guarantor will also be liable only for the 4,000. Now what the provision says, on being sued by the creditor, the surety may have the benefit of set off of any right the principal debtor had against the creditor. अगर कोई right है creditor के against principal debtor का, तो वो set off करने के बाद जो net liability बचती है, then उसी के लिए surety liable होगा. The surety will be liable only for the net liability after making the set off. Clear? The right to share reduction. The surety has right to claim proportionate reduction in his liability if the principal debtor become insolvent. See example number 28. X took a loan of 5,000 from Y, which was guaranteed by Z. X become insolvent and only 25% relies from his property, that is 1250. Now Y will receive 1250 from X and balance amount which is not paid from guarantor, that is 3750. Please read this example clearly. पढ़िए एग्जाम्पल बच्चों. भाई 5,000 का लोन देना था, इंसॉल्वेंट हो गया, 25% रिलाइज हुआ, 1250 रिलाइज हुए, तो बैलेंस अमाउंट ही क्लेम करना है. The surety has right to claim proportionate reduction in his liability. Clear? Now rights against co-sureties. Right to claim contribution equally. If in case of contract of guarantee there are more than one surety, they are called co-sureties. So unless otherwise agreed, each surety is liable to contribute equally for discharge of whole debt or part of the debt remains unpaid by the debtor. Example 28, XYZ had given the guarantee for loan of 30,000 which was lent L to M. Now if the M makes default, XYZ will be liable equally, that is 10,000 each. Simple point, important point. Now this is important. Right to claim contribution only agreed sum. Only agreed sum. If co-sureties have guaranteed for different sum, they are liable to pay equally, but up to the limit. But up to the limit. See the example number 29, 30 and 31. They are important example for examination point of view also. X, Y, Z are sureties to M enter into 3 several bonds, each in different penalty. X in the penalty of 10,000, Y 15,000, Z 30,000. Means they have given the guarantee. X has given the guarantee up to 10,000, Y up to 15,000, Z up to 30,000. Now the default is of 30,000. First distribute equally. First distribute equally. 30,000, 10,000 each. And this 10,000 is within the range of everyone. X, Y, Z, they can pay 10,000. But suppose the fault is 40,000. The 1/3 part is 13,333. But X has taken the guarantee only for 10,000. So X will pay 10,000. Remaining balance 30,000. Remaining balance 30,000, which will be shared by Y and Z equally. Which will be shared by Y and Z equally. भाई 40,000 का था तो इक्वल बांटते हैं तो 13,334 रुपए 33 रुपए बनता है. जेड ने कहा, एक्स ने कहा था भाई साहब मैं तो 10,000 दे सकता हूं. तो कैसे बांटा हमने? व्हाट यू डिसाइडेड कि मैक्सिमम एक्स विल बियर द मैक्सिमम अमाउंट ही इज गारंटेड, he is taken the guarantee, and the remaining amount will be shared by Y and Z equally. Suppose the amount of default is 50,000. Then first X will pay 10,000, remaining amount 40,000. If we divide equally, then it is 20,000. But the Y has taken the guarantee only for 15,000. So Y will pay 15,000 and rest amount 25,000 will be borne by the Z. Sir, what about the loss is rupees 1 lakh? चल रहा है दिमाग में आप लोगों के? Sir, what about the amount is 1 lakh? Then in this case, X will pay 10,000. Y will pay 15,000 and Z will pay only 30,000. So this amount is 30 and 15, 45 and 10, 55. Sir, what about balance 45? Nothing. The loss will be borne by the person who has given the loan. भैया लॉस 45,000 का जो नहीं मिला वो नहीं मिलेगा ना, क्योंकि XYZ has given their limit कि we can pay only up to that amount, right? So this was the unit number 7. सर प्लीज चैट बॉक्स को अलाउ कर दीजिए बच्चों को. Please share your queries so that we can go for the LPL third. सर चैट बॉक्स कर अलाउ कर दिया क्या? Okay, thank you. Please ask your queries, students. Do you have any query, बच्चों? Please reply yes or no. बी पॉइंट, यही तो बी पॉइंट बताया बेटा, अभी पूरा समझाया मैंने अक्षय आपको कि इक्वली शेयर करना है. डिस्चार्ज ऑफ श्योरिटी बी पॉइंट. वेट, रिलीज और डिस्चार्ज ऑफ प्रिंसिपल डेटर. स्लाइड नंबर बताइए जरा इसमें, बी पॉइंट 2 या 3 है बेटा, स्लाइड नंबर बताइए. समर्थ सर, देन इफ प्रिंसिपल डेटर हैज प्रॉपर्टी, then can the creditor own his property up to his debt? No. If he has given as the surety, if he has given the property as security, otherwise he will file the claim in the court, and court will decide the how the payment will be done. Slide number 44. What it says, if the creditor has discharged, क्रेडिटर ने मान लीजिए प्रिंसिपल डेटर को माफ कर दिया, भैया मैं तुमसे पेमेंट नहीं मांगूंगा, तो श्योरिटी भी डिस्चार्ज हो गया लायबिलिटी से. 47 कहती है स्लाइड, इम्पेयरिंग श्योरिटी रेमेडी. अगर क्रेडिटर ने श्योरिटी की जो रेमेडी है, जो बेनिफिट थे, उसमें कहीं कमी की, तो श्योरिटी की लायबिलिटी खत्म हो जाएगी. एग्जाम्पल था 19, शायद आपको हिंदी में की दिक्कत है. एग्जाम्पल 19 था, उसमें क्या था बच्चे कि सी ने पी को एज ए ट्रेनी लिया, और सी ने कहा था मैं चेक करूंगा कि ये हर महीने आके चेक करूंगा कि ये प्रॉपर काम कर रहा है नहीं कर रहा है, कैश जमा कर रहा है नहीं कर रहा है. सी ने ये काम नहीं किया, हर महीने चेक नहीं किया, तो क्या हुआ, जो पी था उसने पैसा चुरा लिया. तो इसमें ऐसी गारंटी खत्म हो जाती है, क्योंकि सी ने वो काम नहीं किया जो डिसाइड हुआ था कॉन्ट्रैक्ट में. ओके, सो लेट्स कम टू द सर पॉइंट नंबर ए एंड बी फॉर रिवोकेशन ऑफ कॉन्ट्रैक्ट ऑफ गारंटी. कैन यू टेल मी द स्लाइड? Slide number, Navdeep, can you tell me the slide number? Navdeep, please tell me the slide number. Then how is possible? What is your exact problem? Please tell me the topic. You are saying, sir, A and B points of revocation of guarantee. A and B point of revocation of guarantee. Actually, revocation of guarantee has 3 points. I'm not sure what you are asking, but as per your doubt, I'm taking the points by notice. And the surety can revoke his guarantee by giving the notice to the creditor, right? If the specific, in case of a specific guarantee, in case of a specific guarantee, it cannot be revoked if the liability is already incurred. But in case of continuing guarantee, the guarantee will be revoked only for future transactions. On invalidation, one more point. Death of surety. In case of death of surety, the guarantee is revoked and for future transactions in case of continuing guarantee. Right? Okay. On invalidation on contract of guarantee, third point. In this case, this point I already discussed 2 times. If the guarantor says that I will be liable only if the co-surety joins, अगर दूसरा co-surety join करेगा तभी मैं liable होऊंगा, तो उस केस में जब अगर co-surety join नहीं करता है तो मेन surety कोई liability नहीं होगी. Sir Sandeep, sir, please repeat point number D. Surety discharged by conduct of creditor. Impairing surety's remedy. This point says if creditor reduce the remedy of the surety, if creditor reduces the remedy of the surety, then surety will not be liable. See the example number 19. Come to that example number 19. What it says, C takes the P as a trainee, and with the and the S is the guarantor. But C also promised that he will once in a month uh, check whether P is working properly or not. But C does not do so. It means C has what is the right of S? As the right of S that she should watch out that whether P is working properly or not. But C did not do so. So in that case, S will not be liable. Sir, when both guarantor and debtor will be liable, अगर guarantor liable हो जाते हैं तो उनकी प्रॉपर्टी से पेमेंट किया जाएगा. सर 143 में ये डिस्टिंक्शन कैसे होगा कि वो चीज इम्प्लाइड था या क्रेडिटर ने इंटेंशनली कंसील किया था. देखिए ये तो यू आर टॉकिंग अबाउट इवन 143, इवन इन द होल लॉ डिपेंड अपॉन द एविडेंस. So then if anyone is claiming that this is done by intentionally or innocently, that to be proved in the court. The law is saying what could be or what could not be. Okay. सर 1 लाख रुपए की सिक्योरिटी थी, 1 लाख और 1 लाख रुपए का लोन था, उसमें सिक्योरिटी थी ज्वेलरी. अक्षय सुन लीजिए प्लीज. 25 एग्जाम्पल. 1 लाख रुपए का लोन था, सिक्योरिटी ज्वेलरी थी, 95,000 रुपए रिकवर हुआ केवल, तो 5 ईयर का पेमेंट रह गया ना, इसलिए 5 ईयर के लिए समर लाइबल होगा जो श्योरिटी था. ओके. सो कम टू द LPL 3 थर्ड मैच. रेडी. Section 142 of the Contract Act 1872 deals with guarantee obtained by free consent, obtained by fraud, obtained by misrepresentation, none of the above. Any guarantee obtained by means of misrepresentation made by the creditor or without his knowledge and assent concerning a material part of the contract is valid, invalid, both A and B, none of the above. A continuing guarantee may at any time be revoked by surety as to the future transaction by giving notice to creditor, principal, debtor without giving any notice to any person, none of the above. As per section 143, the Contract Act of the Contract Act, guarantee obtained by creditor by concealment is invalid, valid, both A and B, none of the above. Next question. A surety has a right of indemnity and right of subrogation against principal debtor, creditor, co-sureties, all of these. A surety is not discharged if a contract to give time to principal debtor is made by creditor with principal debtor, third person, either A or B, none of these. Let's check the answers. 142 obtained by misrepresentation. Invalid. May be revoked at any time by surety as to future transaction by giving notice to creditor. 143 guarantee invalid. Subrogation against the principal debtor. A surety is not discharged if the contract to give time to principal debtor is made the creditor with third person. ठीक है, चलिए चेक करते हैं. मिस्टर दक्षता सिद्धार्थ, इकरा, अक्षित, दीपक, Ushri. So these were the person who have given the correct answers. Megha ma'am, are you there?
Yes, sir.
Please. Good afternoon, ma'am.
Good afternoon, sir.
Over to you, ma'am.
Sir, some questions to be discussed, or we'll take the queries?
Ma'am, I think time is
Okay.
4:07, so we should take the queries.
Okay. If dear students, if you some student is having any queries, they can raise their hands from this unit or from the earlier units of the Indian Contract Act. Yes. I don't think so, sir. There are some queries. Sir, yes. Today we have finished unit number 7, that is contract of guarantee and contract of this contract of indemnity and guarantee, and the notes and assignment are already being uploaded. And on Wednesday we will start unit number 8, bailment and pledge. Okay, one query, common query I was receiving from the BOS knowledge portal, that since RTP is not issued for September 2026, it is not uploaded. Some students who have from the earlier attempt or from May 2026 or from the earlier attempt who has completed the syllabus. Okay, they were asking that whether, ma'am, we can attempt the RTP of the earlier attempts or suggested answers. Yes, dear students, we already always discussed that whether RTP is for 4 to 5 attempt is available May 24 and May 24 onwards, and your suggested answers, your mock test paper also. You can refer all these publications provided there are some amendments to it, like amendment which recently in the small company. So you can modify the answer accordingly, since some questions, only amendment in the Companies Act is relating to small company right now, which we will give to you in the September 2026 RTP properly. So if any question is there on the small company in the previous attempt, you can change it accordingly yourself. You can take the limits of small company paid up share capital 4 crores to 10 crores, and this turnover 10 crores, it has increased to 100 crores. So that portion you can change accordingly. rest assured, all the remaining provisions, be it your contract, SOGA, partnership, companies, LLP negotiable, are same. So you can start referring the RTP suggested answers. You can crop the questions. RTPs may questions are given chapter wise. Chapter 1 you can refer, chapter 2 you can refer. But in the suggested answers, in the mock test paper, the questions are provided in the sample question format. So you can pick out the questions of the Indian Contract Act, because in all the questions, contract name, the name of the act is written. So you can easily pick out the questions of the Indian Contract Act. Remaining two units are still there, so you can wait till Friday, and upon completion of the whole chapter from the study material, you can refer the questions. And one more query, ma'am, how we can prepare notes? From where we can refer the notes? So, dear students, for notes, I already intimated to you that you can refer the notes available through this LVC class. These will also serve as the purpose of notes. Other thing, second, you can refer the Saransh also, because Saransh we have given the concepts in flowchart diagrams, and also we have provided two type of summaries at the end of each study material. Summary in the form of concepts and summary in the form of flowcharts. Okay, so all these three things will serve as the purpose as notes, but instead you you want to make notes, you can prepare notes in the study material, you can underline the important concepts. So there is, according to me, there is no need to prepare separate notes, because time is very less. You have to complete the whole contract act chapter 1 from the study material and practice the same. So according to me, there is no need. You can refer the LVC notes, you can refer the Saransh, and you can refer the summaries also. So on Wednesday, we will take unit number 8, that is bailment and pledge. Sir,
Ma'am,
can we
one thing I
yes,
want to share,
yes,
that
yes,
this PPT has about 9 to 10 questions for practice, and
yes,
also given the I have also given the answers. So students should definitely go through the questions after the revision of the topic. So that will
yes.
be helpful for the practice point of view.
So many questions, sir. Today also we have discussed some concept of co-surety. Sir, the same question come in the May 2026. So I am again emphasizing that all the questions we are discussing in the live virtual class, in the notes, in the assignments, all are very important. The concepts are discussed recently, 5-10 minutes before, about the co-surety, about the variance in the terms of agreement of the creditor. So all these type of questions recently came in May 2000, and they generally come from the Indian Contract Act. You can see that around 32 marks out of 120, because there are 6 questions, choice is there in one question. So around 32 marks question generally come from the Indian Contract Act. So you can understand the importance of this topic. This topic is vast, lengthy, we can understand, but it is scoring also. It is very easy. And sir ने जिस तरह से आपको पढ़ाया है, it becomes more easy. But rest assured, you have to study at your own also. Okay. So, sir, we can end the session here.
Ma'am, please.
Yes, sir.
Thank
Sir,
you.
dear students, we will now meet on Wednesday. Please complete unit number 7 from the study material. Thank you.
Thank you,
Thank
ma'am.
you,
Thank
sir.
you so much.
Thank you. Yes.